Miss Spink, is that correct?
Yes.
Okay. Not seen the lawyers connected yet. We had one hearing set for 1:30 and another one set for 2:15. So I'm not sure if they're.
He just texted me and said he was on waiting.
Okay. I'm just gonna check with my office real quick.
Okay.
So if you can just hold on for a minute. right, Mr. Gilbert, are you able to hear me okay?
I am, and can you hear me?
I can, thank you. And we've got Mr. Corcoran connecting. Okay, Mr. Corcoran, are you able to hear me okay?
Yes, Your Honor, thanks. Good afternoon.
Okay, so we've got everybody connected. The record should reflect that Ms. Spink is present here in the courtroom today. And we're on the record now in two different files. We have file number 231411. And we have file number 231421. And the second file is an appellate file. That's an appeal from the district court. And the other one is a suit that was filed here in this court, contract action. So we've got a number of matters up for hearing today. As to the circuit court file, we have a motion from Mr. Corcoran to enter a default judgment. We've got a motion from Mr. Gilbert to set aside the default. And so I guess before we go forward with the entry of a default judgment motion, we would need to address the issue of having it set aside. So Mr. Gilbert, I did receive your brief. I think it was filed recently on July 1st, maybe. So I suspect Mr. Corcoran, you didn't have time to respond in writing. Mr. Gilbert, what would you like to say in support of that motion?
Well, the issue with that file is Mr. West, who was originally on that file, along with Mr. Beckwith, they were both co-plaintiffs on it. There was litigation between Mr. West and Ms. Spinks and one other, Mr. Dunn. The court ruled in that motion early on that Mr. West was supposed to vacate the storage unit. Mr. West had sublet a certain portion of that, I guess, to the co-defendant. He was at one point ordered to retrieve his personal property or vacate the personal property. He didn't. When the storage unit was actually cleaned out, there wasn't anything in it. But to the first part of that, the case should not have been filed because it's still got it's got an appeal pending regarding Mr. West. So when Mr. West filed that instant case along with the co-defendant, it would have been improper as to Mr. West, and I believe he eventually did drop out on that. The other issue with this one is Miss Spink resided at one location for a period of time during the course of that action. She eventually moved out of her residence and moved in with a significant other. I think the proof of service shows that she may have been attempted to be served at a business location, which she's hardly ever there. She's there for maintenance a little bit in the morning and the afternoon. Anyhow, we filed an affidavit from Miss Spink stating that she was never served that process. We have been finding out most of these hearing dates by Miss Spink's looking at the court dockets and trying to figure out ahead of time what's going on. And that's going to be an issue on one of my other cases this afternoon. So I think there's a couple issues with whether this case could even move forward against Miss Spink. If it were to move forward, then we'd also have to include Mr. West. I think you have the answer and you have our affirmative defenses. Frankly, this is nothing more than Mr. West attempting to continue to harass Ms. Spink. The underlying trial that I had alluded to was a quasi-divorce we had a visiting judge for that one, and I think that might be even close to a term he used. Mr. West just doesn't want to live with the issue the way it is, and he's made comments in the past that he's going to do everything he can to make Ms. Spink's life miserable, and that's just a portion of where we're at today. So that's where I'd leave it up to the court.
Okay, so I got some questions, because first of all, Mr. West isn't even part of this lawsuit anymore. He was dismissed back in August of 2023 out. So he's not a plaintiff in this lawsuit anymore. So I don't even know why we're talking about Mr. West in the context of this file 231411.
If I recall right, if I'm recalling my dates correct on this, the default was entered at the time before he was dismissed.
Okay, so what does that have to do with anything?
Well, he would have been
he's not part of the case now, so why are we talking about him?
because my personal belief is he's the one that's promoting this case. And even in negotiations to resolve this with Mr. Beckwith, we've been made well aware that if we should satisfy Mr. West, this case will go away.
Okay, but what is your personal belief about what's going on behind the scenes have anything to do with my ruling on the default?
Well, I guess it doesn't, but as far as the default goes, the plaintiff or the defendant, Ms. Spinks, has never been properly served.
Okay, so the complaint in this case, and I'm going on what's in the file here. The complaint in this case was filed on February 13th of 2023. There's a proof of service filed by Rick Robbins that indicates that Ms. Spink was personally served on March 25th of 2023. The default was entered on May 8th of 2023. So I mean, the proof of service shows that she was personally served in March of 2023. And your motion to set aside the default is talking about something from February of 2024, which is way past any of those things.
But she's still never been served on this file.
She has been served. There's a proof of service in the file dated that she was personally served with the summons and complaint on March 25th of 2023.
And her affidavit says that she wasn't.
Okay, well, I mean, then I guess we need to have a hearing and we need to call in the officer who personally served her.
Can
But
I freely speak?
no, your attorney's here to speak for you.
Oh,
In your motion, Mr. Gilbert talks about addresses and so forth. If she was served personally, then how would the address she was at make any difference?
If she was served, she says she
Okay,
has
so you're
been
saying
served.
you're saying that the deputy from Kalkaska County filed a false proof of service, that he didn't actually personally serve her on March 25th?
She said she didn't. She wasn't.
Okay. All right, Mr. Corcoran.
Your Honor, just, I guess I'll start from the beginning, or the end. And that is, I got the motion to set aside default with no affidavit, no brief at 11 o'clock today. I've checked my mail. I haven't gotten it via mail. I was literally on the court with the clerk in Kalkaska to see if anything had been filed when I saw my email come in. Number two is, I've known Rick Robbins. I came up north in 1988. I think I met him a year or two later. I've known the guy my whole career. I don't think he would put his license up and I think he knows who Ms. Spink is. And if we have to bring him in to testify, I guess we will. Number three, Your Honor, I don't see an affidavit of meritorious defense. I just want to point out a couple quick things about the claim. Glenn Beckwith was never a party to the West versus Spink case. He was in this storage unit at storage, his and her storage with Mr. West. They had literally improved this thing to where they could live in it if they had to. He was living in it. They had heat, water, etc. Mr. Beckwith can fix anything. So he had literally 20, 30 years full of equipment stored in this place of his own. When Mr. West and Ms. Spink had a breaking up or a falling out in 218, Mr. Beckwith started doing all of Ms. Spink's maintenance in exchange for staying in the storage unit. And so when we're in a lawsuit in 21 and Judge Power signs an order that says Mr. West needed to get all of his personal property out of the storage unit, I fully expected at that point that Mr. Gilbert or Ms. Spink would file either a landlord-tenant action or a storage unit eviction against Mr. West and literally any and all occupants. That was never done. I did seek to have the court reconsider that order, and it didn't. And then we went to trial. I did try to present damages that Mr. West suffered, not Mr. Beckwith. Judge wouldn't let me do it. So that is part of the appeal. But Mr. Beckwith's claims never been litigated. It is not disputed that Ms. West or Ms. Spink never went to landlord-tenant court, which is what I think she should have done since he was living in the unit. But even under the Storage Unit Act, you got to do something. And so what she did is they went in at a midnight several months later and took everything out of there and never made it available to Mr. Beckwith to come get. He's never had a chance to redeem his property. He has a very detailed analysis attached to his affidavit because that's essentially the orderly liquidation value if he were to go on, say, Facebook and liquidate all this stuff. And so he has a separate cause of action, clearly. And we filed the lawsuit over a year ago and no motion has been filed. And so I just don't think there are grounds to set aside this default judgment, Your Honor. And I guess if the court is going to do that or the default, then I certainly would ask the court to condition on a grant of cost. And I'm at $275 an hour, and it's probably 4 hours of my time to deal with all that. But I don't think sufficient grounds have been met. Obviously, the court's going to make the call there, and if it does, then we'll deal with it. But I appreciate it. If you have any questions, I'm happy to answer them.
Quick rebuttal on that, Your Honor. It was not at midnight. The sheriff was present. So as far as the contents, I suppose we could bring the sheriff in if it's inclined to continue with the default for the findings of what was actually in there.
Yeah, okay. All right, here's the thing. We have a complaint that was filed in this case on February 13th, 2023, as I indicated. There's a proof of service that Ms. Spink was personally served with the summons and complaint on March 25th of 2023. The default was entered in this case on May 8th of 2023. And as counsel knows, there's a difference between the default and a default judgment. So the default has been entered since May of 2023. Mr. Gilbert didn't file an appearance on Ms. West's behalf until October of 2023, 5 months after the default was entered. And that's the first thing that was ever filed on Ms. Spink's behalf in this file. She did file an affidavit with the motion to set aside the default. And that indicates that she did not receive service or notice by mail or personal service of the notice of default. It doesn't say anything about the original complaint. So I don't have any evidence in the form of affidavit or otherwise to indicate that she wasn't actually served by personal service on March 25th with the complaint. So there's no reason to set aside the default from May of 2023. Now we have the issue. So the court's going to deny the motion to set aside the default. The court has not entered any judgment in this case yet. And under Rule MCR 2.603, that covers default judgments entered by the court, and I'm referring to specifically 2.603B3. I do find that the plaintiff is entitled to a default judgment. However, under sub rule 3B, if in order for the court to enter that judgment, it's necessary to take an account or determine the amount of damages, then the court can hold hearings as necessary. And looking at the motion for the entry of a default judgment, I mean, there's substantial damages claimed.
Right.
And so I think the court would need to set this for probably at least a half a day evidentiary hearing to determine the nature and the amount of damages in this case. And so I'm going to put that back to you, Mr. Corcoran, in terms of the amount of time. How much time do you think you would need to present evidence in support of the amounts that you're requesting?
Your Honor, I think a half a day is probably sufficient for both sides to present that.
All right, Mr. Gilbert, is a half a day enough time?
I believe so.
Okay, so the court's going to set this for a half a day evidentiary hearing. And Mr. Corcoran, I'm going to ask that you prepare an order that reflects the ruling of the court today, just indicating that the motion to set aside the default is denied. The court's granting the motion for entry of a default judgment, and the court is setting it for a half a day hearing to determine the amount and nature of the damages.
Will do, Your Honor. I'll send that over to Mr. Gilbert for approval in advance. So,
all right, so that takes care of what we have on the docket for file 231411. The next file is the appeal file, and that is file number 2314281. And in that case, there was a claim of appeal filed back in 2023. And essentially nothing's happened on it since then. Mr. Corcoran, you're asking the court to set deadlines for briefing, is that correct?
yes, Your Honor. Briefly, I went over on the last day for appeal and tried to file it. And because the district court had already closed by a half hour, I couldn't file it with the registry of actions. So I had to come back the next day and file. And what I did there was I put an attachment with the reasons for the late appeal. And I should have motioned this up sooner. I assumed the court was going to set it for a hearing or a scheduling conference. But yes, I'm asking for the court essentially to accept the late appeal. I can have a brief filed literally in 2 weeks. The transcript is not voluminous at all. And then have the court set an oral argument date and give Mr. Gilbert time to reply. That's really what I'm asking for.
All right, Mr. Gilbert.
Sounds reasonable.
All right, so the court is going to order today that the appellant is to have 30 days from today's date to file their appeal or their brief on appeal. Mr. Corcoran, if you can just indicate on your brief that you're requesting oral argument. Once your brief is received, then my office will set a date for the oral argument on the appeal. And then Mr. Gilbert, you'll have 30 days from the date that Mr. Corcoran's brief is filed to file your brief. And so Mr. Corcoran, you just need to make sure, of course, that you serve opposing counsel with your brief so that he knows when his date starts running. Once the court has received both briefs, then the court will set it for oral argument. And Mr. Corcoran, I'm going to ask that you prepare an order reflecting that issue as well.
We'll do so, Your Honor.
All right. Mr. Corcoran, anything else that we can address?
Well, yeah, lastly, Your Honor, the motion that I filed, the motion for relief from judgment, because it's, on appeal, I filed a companion motion in the appellate case. I guess what I would suggest is that we notice up that motion for the same time as when the court hears oral argument. It was a motion for relief from judgment because according to my inspection of the district and circuit court files here, there was no writ of restitution issued. And, again, both Mr. Beckwith and Mr. West's property were taken from this, what we'll call the Blue Barn. And that was the subject matter of the appeal. So I have
is that not something that's part of the appeal?
It is appeal, but as I read the court rule, when there is an appeal, if you're seeking relief from judgment, you have to go to the appellate court, not the trial court. And so that's why I filed it, the 2612 motion under 7208. So I mean, I'm happy to notice it up at the same time we have the oral argument, so the court can have time to reflect on it.
All right, yeah, I think that would be a more efficient way to do it.
I can put that in the order as well.
Okay.
Okay, thank you.
All right, Mr. Gilbert, anything else from your side today?
Not on this case, Your Honor.
Okay, and then, Mr. Gilbert, I know you've got the hearing at 2:45. If you want to disconnect and reconnect, you can. Otherwise, I can just place you in the waiting room until then.
I'll disconnect. Thank you.
Have a good day,
Okay.
gentlemen.
All right, thank you.
Paul Jeff West. Paul Jeff W. Yeah, so I will follow up. That's all part of it, all right? So I can nail her then, and I'll have that transcript. Well, here's what I will do. At that hearing, I'm gonna say, Ms. Spink, you understand that you testified at the district court, didn't you? Didn't she admit finally that you were the title owner, or did she try to say she was the title owner?
Okay, if I could have both counsel unmute and we'll go on the record in Blake West versus Joseph Vaillancourt. This is case number 2314318. If I could just have counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. Attorney David Gilbert appearing on behalf of both plaintiffs in this matter.
Okay, we're on the record in this case today for a status conference. The court had referred this to mediation as part of its pretrial order. The court did select a mediator. I did receive notice from the mediator back in looks like late April, indicating that she hadn't been able to communicate with either side, so she backed out of her role as mediator on that basis. The court then set this for a status conference in June and then reset that for today. So I guess, Mr. Gilbert, on behalf of plaintiff, can you tell me where things are at and what we need to get on the schedule to keep things moving here?
Mr. West was charged with causing this accident. That trial was conducted late last week and completed. So having that resolved, we can move forward with the final portions of discovery. He was charged with a motor vehicle moving violation causing serious injury, and he was found not guilty. Had he been found guilty in that action, that would have changed the dynamics of the case overall. So now we've got that done. I have yet I don't have policy information on this, but given what I'm to understand on it, the policy limits are fairly low. So even though mediation or arbitration would normally be required, I don't know that policy limits would satisfy anything that would come out of that. However, the court wants to reschedule this and put it back on the trial docket, that would be appropriate.
All right, thank you. Mr. Paul, do you have any input into that?
Well, I would say this, Your Honor, that Mr. West was acquitted of the charge of a moving violation, and I think, having sat through the trial, the reason for that is quite obvious. The prosecutor didn't prove a moving violation, didn't have the evidence marshaled to do so. But in fact, the plaintiff in our suit, defendant in that criminal suit, was convicted of reckless driving, which it seems to me is a moving violation. But at any rate, he was convicted of reckless driving, and it is his reckless driving that caused this accident, and we intend to prove that in the context of the civil suit. What concerns me at this point, before we proceed further, is that given that Mr. West, who was the operator of the motorcycle involved, has been convicted of reckless driving, and given that we intend to prove that he was the cause of the accident, it seems to me that there is a conflict in one attorney representing both Mr. West and the passenger on his motorcycle, Ms. Trimark. I don't know. That's just the feeling that I have, that it doesn't seem quite right, because she has a claim back against Mr. West, and I think it's a colorable claim given the fact that he's been convicted of reckless driving.
As far as that issue goes, the conviction for reckless driving was prior to the accident, and the video shows that the defendant in this case made a left-hand turn approximately. Well, he had 6 seconds to observe the video. As far as any potential conflicts goes, I have spoken with both the plaintiffs, and neither one of those have an issue with me representing both.
All right, well, discovery right now, according to our pretrial order that we entered back in February, discovery is set to expire in August. So do you want to extend those dates out?
Yes, I would suggest we extend all of the dates by about 90 days, Your Honor, if that's acceptable.
All right, Mr. Gilbert, do you have any objection to that?
No.
Okay. Okay, so here's what we'll do. I'm going to extend the dates out 90 days. I'm going to set a dispositive motion cutoff 30 days following the close of discovery after that 90-day extension. And then I'll set it for another status conference at that point. If there's been motions filed, then we'll have those heard and decided. If there haven't, then we can see where the parties are at. If Mr. Gilbert, I understand what you're saying about mediation, but we can explore that more at that time once discovery is closed, and if either side files any dispositive motions, because that may have an effect, of course, as well.
Well, Your Honor, with all due respect to Mr. Gilbert and to your observation, I do think the case should be set for mediation. I don't think it's a policy limits case. I think there's substantial questions of fact here. Mr. Gilbert talks about that 6 seconds, but he has nobody that's testified to it. It's just something that he's observed.
Okay.
Well, actually, during the course of the trial, the officer watched the videos and testified to it. So it is what it is.
He didn't testify to it. He just kind of agreed with you. And that officer did the worst possible investigation of this accident that could ever have been done.
Okay, well, I typically do order mediation unless both parties agree that it's not going to be fruitful. So again, that's something that we can address. So I'm going to put out a scheduling order that reflects these new dates, and the court will also send out notice of the date and time of hearing for that next status conference in about 90 days, and we can do further scheduling from there. Mr. Gilbert, anything else I can address for your side today?
Nothing further, Your Honor. Thank you.
Mr. Paul?
I have nothing further, Judge.
Okay, thank you. We'll put those orders out, and that's all for this hearing. Parties on this case are free to disconnect.
Thank you, Judge.
Hi there at Wexford County. What case are you guys calling in on?
Let them know what your name is. My name is Blake West.
Mr. West, we just had the hearing in your case, and if you need to find out about that, you can talk to Mr. Gilbert, your attorney, but essentially the court just set some additional dates for going forward.
Set some additional dates.
Yep.
Okay. I didn't even know that I was having any of this. I should have I thought it was all the 15th. I thought I had to go to Kalkaska.
Yeah, this is part of a civil case that we had the hearing on today. I'm not sure what other matters that we have.
Okay.
So Mr. Gilbert is your attorney on the civil case, and he can explain more about what happened today in this part of your matters, okay?
Okay,
All right, thank you. Okay, can I see that Richardson? All right, ma'am, can you tell me your name, please?
Cassandra Lane.
You're breaking up there. Can you tell me your last name again?
Lane.
Lane?
Lane. Yeah.
What case are you calling in on?
A divorce case.
Are you sure that's in front of my court? This is Judge Mertz.
Yep.
I'm not seeing that on my docket today.
It should be, I have for 7/2 at 30.
You have that piece of paper with you that says that? I'm not seeing that on my docket.
I do have it right in front of me.
Can you give me your case number, please?
Yep. 241457-DO.
Okay, we're gonna take a look. Just 1 second, all right?
Okay.
Oh, Lane.
It's for a default divorce.
I don't have anything in there for a default. Um. Yeah. This came in when I was on vacation. See a proof of service or anything if there isn't.
Okay, Miss Lane, I'm gonna put you on hold for a minute. I'm gonna see, this didn't make it onto the docket, but I'm gonna see if there's a way we can address this for you here today, but I gotta put you on hold for a little bit, all right?
Thank you.
Okay. right, looks like we've got everybody connected, so we'll go on the record in Richardson versus Chubb Insurance Company, Auto Owners, and Jill Rose. This is case number 2414376. And if I can just have counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. My name is Todd Stern. I am proudly appearing on behalf of Maureen Richardson in this matter.
And
Good
good
afternoon, Your
afternoon.
Honor. Sorry, Chrissy. Good afternoon, Your Honor. Trevor Potter on behalf of defendant Great Northern Insurance.
Good afternoon, Your Honor. Christy DeVos appearing on behalf of defendant auto owners.
All right, thank you. This is Auto Owners' motion for summary disposition, and I did have a chance to review the submissions of the parties. And Mr. Stern, just based on your submission, it looks like your issue is just whether or not the dismissal is with or without prejudice. Is that fair?
Yes, Judge. As I said in my motion, I won't belabor the point, but like if something were to happen and Great Northern decides to either rescind the policy or they decide that they're going to issue some kind of a reservation of rights, or I don't even know what could happen, but in the event that Great Northern decides that they're not going to cover the no-fault benefits, I don't want to be left out, hanging. So I've been willing to dismiss them. I sent an email to Ms. DeVos a month ago almost saying I'm happy to voluntarily dismiss. So I'm not intending to keep them in the case, but I just feel like my client needs a protection just in case.
All right, thank you. Ms. DeVos?
Thank you, Your Honor. Our concern is just that we were brought into this case when there's no dispute that there's a higher priority insurer. There's no coverage issue. There's no evidence of any rescission or intention to rescind or even any facts supporting a rescission. It just seems like we were brought into the suit when we shouldn't have been. And my client's concern is that if the dismissal is without prejudice, that we're going to continue to be sued every time there's a disagreement on what benefits are owed, even though we aren't the higher priority insurer.
All right, Mr. Potter, does your side take any position on this?
Not particularly, Your Honor. I think our answers to the request for admission submitted from co-defendant speak for themselves. I've spoken to plaintiff's counsel. My client was paying before the lawsuit, and now there's a dispute as to what's reasonable and the amount, but we were paying before, so there's no intent now to rescind any policy, but that's as far as I'd like to go today.
All right, thank you. Mr. Stern, it's your motion. Anything that you wanted to say in response?
No, Judge, I think you've got the issue. It's just your call at this point, I guess.
All right. I mean, I did have a chance to look at this. I guess I can really see this from both sides. I understand auto owners' position. They're not priority. They're never going to be, and they want to be out of this. But I also can see plaintiff's side, and I don't think there's any real clear law on this particular kind of situation. I think it's, more of a almost an equitable kind of a situation. So, number one, I find that as things stand now, auto owners is entitled to summary disposition for the reasons stated in their motion. And so the court is going to grant the motion and dismiss any of the claims against auto owners. However, I am willing to make that without prejudice at this point because, again, I think for the reasons stated by Mr. Stern, and I don't think there's any specific legal prohibition against the possibility that things could change. So the court will grant the motion for summary disposition without prejudice. Ms. DeVos will just ask that you submit an order either under the 7-day rule or with the stipulation as to form from counsel. And Ms. DeVos, anything else I can address for your side while we're on the record here today?
No, Your Honor. Thank you.
Mr. Stern?
Your Honor, if we could just have one, I do appreciate the ruling. Thank you so much. We did assert an uninsured or underinsured motorist claim, I believe, against auto owners, so I don't want that part of the case dismissed. The dismissal should only be as to the no fault allegations.
That was all we filed on today, Your Honor. So I understand that. My order is only going to be as to the PIP claims
Yeah,
proposed.
yeah, I agree.
Thank you, Judge. Nothing else, though. Thank you so much for hearing this matter today.
Mr. Potter?
All set, Judge.
Okay, thank you. All parties on this file are free to discuss this time.
Thank you, Your Honor. Have a great weekend.
Thank you, Your Honor.
Have a nice 4th of July, Judge.
Okay.
I bought judgment of divorce too, if you're so inclined.
Sit here for now.
Okay.
Unless he's part of the litigation, he cannot sit at the table.
Sorry.
This is Mrs. Chipman, right? Did I get it right? Okay. It's gonna be a minute. I've got another hearing.
Oh, I'm sorry.
Do I need to move?
Nope. you're good.
Okay.
I thought we were there. Oh, the gal that cut, sorry, yeah, I missed that one.
He's just jumping the gun.
Oh, we're way early. I'm sorry. I thought that was set for 3. I'm sorry, Judge.
I thought it was 3 too. Oops.
All right, Miss Lane, are you able to hear me?
Yes.
Okay, I had a chance to take a look at your file, and the reason why we didn't get it set for hearing today is under the law, we're required to wait a certain period of time before the court can hear your motion for default judgment. And because that was just filed on June 24th, it's not enough notice to Mr. Lane. So I'm gonna have to reset this for August, which is my next date that I'm hearing court here in Kalkaska. It'll be at the beginning of August. But we'll send out a notice of the date and time of that hearing to you. It'll be by Zoom like we're doing today, okay?
Okay.
Did you have any questions about that?
No.
Okay, and you don't need to file anything. I see that you filed a proposed judgment of divorce already. So you don't need to file anything. Just watch for that notice in the mail. Is your address on Haskins Road Southwest in Fife Lake?
Correct.
Okay. All right. That's all for today, and you're free to disconnect at this time.
Thank you.
Okay.
Are you okay? Oh my gosh. I'm okay.
Okay, all right.
Clumsy. Is
I
this
put
what you're
a,
looking
need to
for?
put a yellow warning strip on.
I know. I was bound to do it one day.
Good afternoon, Your Honor.
All right, good afternoon. I've got an individual named Daryl Brandt who's connected. Can you tell me what case you're connecting on, sir?
Are you talking to me, Your Honor?
I have somebody connected named Daryl Brandt. I need to know what case you're connecting on, please.
Okay, hold on. I'm gonna get my glass this one?
Yeah.
It's 24-14450 DO.
Okay, I don't have that case on my docket today. This is Judge Mertz's courtroom. Are you sure you're in the right spot?
Yes.
Okay, we're gonna look up your case. So just, I'm gonna put you on hold for just a minute, okay?
You got that one?
Okay, Mr. Lum, are you ready to proceed on your case?
Yes, Your Honor, we are.
All right. And I have this set for hearing on a motion to for entry of a default judgment of divorce. Is that correct?
That's correct, Your Honor. Yes.
Okay, and I am in receipt of a proposed judgment. Mr. Richards, if you could raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. And Mr. Lum, if you want to go ahead and proceed with the statutory proofs, please.
Yes, Your Honor, thank you. Mr. Allen, could you please state your full name for the court?
Stephen Allen Richards.
And is it true that you signed a complaint for divorce on or about February 21st, 2024, which you caused to be filed with this 46th Circuit Court?
Yes.
And at the time of the complaint for divorce, have you been a resident of Kalkaska County for at least 10 days?
Yes.
And a resident of the state of Michigan for 180 consecutive days? And at the time the complaint was filed, were the allegations in the complaint true?
Yeah.
And are those allegations still true today?
Yeah.
And is it true that there has occurred a breakdown in the marriage relationship to the extent the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage can be preserved?
That's correct.
And is it true that you were married on September 15th, 2007?
Yes.
Were there any children born of your marriage?
No.
To your knowledge, is your spouse, Irina Samina, pregnant at this time?
No.
Have you had the opportunity to review the default judgment of divorce that we signed and presented to the court?
Yes.
Are you requesting spousal support at this time?
Yes. Could you repeat that, please?
Are you requesting spousal support at this time?
Oh, no, absolutely.
Do you understand that by not requesting spousal support now, neither of you may later come back to the court and request spousal support?
Yes, I understand.
Do you believe the do you believe the judgment of divorce are fair and equitable?
Yes.
Are you asking Judge Mertz to enter this judgment for divorce with the court today?
Yes.
Do you have any questions for me or the judge?
No, I do not.
Your Honor, do you have any questions for my client?
I do not. So the court has heard the testimony of Mr. Richards. The court has reviewed the file prior to today's hearing. The court finds that there was proper service of the complaint for divorce in this case, that the defendant failed to defend or otherwise appear, that there was a default entered. Based on the testimony of the plaintiff, the court finds that the statutory grounds for divorce have been met. I have had an opportunity to review the proposed judgment. As council's aware, regardless of whether or not it's default, the court still has to make sure that the judgment is generally equitable. I have reviewed it and I find that it is, and otherwise contains all the provisions required by statute. I've signed that judgment of divorce with today's date. Mr. Lum, anything else that we can address for your side here today?
That's all, Your Honor. Thank you.
Okay, thank you. That concludes this hearing, and you're free to disconnect at this time.
Good afternoon. Thank you.
Thank you, Judge.
Thank you. Mr. Brandt, if you're able to hear me, I don't know if you're connected or not. I'm going to ask that you contact my office at 989-731-0224. My assistant is Jennifer. You can give her a call. We'll be able to straighten this out and get you on the docket because your case was not on the docket for today's date. All right, that concludes our afternoon docket.